Let's be real for a second. Even the most seasoned professionals have scrolled all the way to the end of a massive agreement, hit that wall of tiny, dense, standard legal text, and just signed on the dotted line. I mean, we've all done it, right? But ignoring those boring boilerplate clauses, that can absolutely cost you time, a ton of money, and in some cases, it can literally tank the entire deal you just worked so hard to put together.
So, welcome to this explainer. Today, we're going to decode all that dense legal jargon and translate it into plain, simple English. Our goal here is to make absolutely sure your next contract negotiation leaves nothing to chance.
Here is our roadmap for today's explainer. We'll start with what boilerplate clauses actually are, why they matter so much, translate some of the most common ones you'll see, talk about if you can negotiate them, and then wrap up with a highly valuable, screenshotable checklist.
All right, Section 1. What exactly are boilerplate clauses? Think of a contract like a giant puzzle, split into two main parts. Part 1 is the main deal. This is the exciting stuff. It's the price, the specific work you're doing, the deadlines, the deliverables. It's what you actively negotiated. But Part 2? That is the rules of the game. That's your boilerplate. These are those standard repetitive clauses that lawyers use over and over again. They don't care about your specific daily project tasks. Instead, they establish exactly how the contract works as a whole, and way more importantly, what happens if the whole thing goes sideways. Moving right along to Section 2, why these clauses matter.
You might think you can just ignore these standard rules, but here's the absolutely crucial takeaway. The main terms decide what you get, but the boiler clauses decide how you protect it. These standard rules hold immense power over your business. They literally dictate your cost of fighting a dispute, your actual chances of winning, and exactly how long that fight is going to drag out.
So, let's get into Section 3, Common Clauses Translated.
First up on our translation list is governing law, or sometimes you'll see it called applicable law. When you spot this, the contract is essentially asking, hey, if we ever have a legal issue, which specific rule book are we going to use to interpret this agreement? It dictates exactly which countries' or states' laws apply.
So if the legal text says, this agreement shall be governed by the laws of India, the simple meaning is that if there's a dispute, we are using Indian law, and we are completely ignoring any other country's laws. Why does this matter? Well, think about it. If you're based in India, but you blindly sign a contract that says the laws of another country apply, you have instantly put yourself at a massive legal disadvantage. You're playing an away game with their rules.
Next up is jurisdiction. Now, if governing law is the rulebook, jurisdiction is the arena. This clause specifies exactly which city's court a case must be filed in. It literally tells you where the legal battle is going to take place.
If a contract dictates exclusive jurisdiction in Delhi, that means if we fight in Delhi courts and nowhere else. This is huge. Imagine you run your business in Kalyan. If you blindly sign a contract with exclusive jurisdiction in Delhi, you might suddenly find yourself forced to travel across the country, hire entirely new lawyers far from home, and pay all those travel costs just to defend yourself? No way you want that surprise.
Translation number 3 is dispute resolution, which often mentions arbitration. This details the specific mechanism of how a dispute will be resolved. Will you go to a traditional public court with a judge, or will you use a private arbitrator? Any dispute should be referred to arbitration in Mumbai. The simple meaning is, we are completely skipping the public court system and will use a private arbitrator in Mumbai instead. Arbitration is generally a faster, private process. But this clause drastically affects the time, the cost, and the entire procedure of resolving a fight. You absolutely need to know which path you're locked into.
Okay, moving on to clause number 4, the entire agreement clause. Honestly, this is a big one. It declares that the physical document you are signing is the complete and final agreement between everyone. What does that mean for you? It means earlier phone calls, past drafts, and previous promises simply do not count.
You might think, oh, we agreed on that extra deliverable over WhatsApp, so we're good. The reality? Actually, scratch that. Those WhatsApp messages mean absolutely nothing if you have an entire agreement clause. Only what is written in the main document counts. If a crucial detail was discussed in a chat but missed in the final draft, you cannot rely on it later. Always make sure every single important thing is actually written into the contract itself.
Translation number 5 is notices. This clause is essentially your official communication rulebook. It explains exactly how formal communications, like, say, terminating the agreement, must be sent, to which specific address or email ID, and when it is legally treated as received.
You can't just shout, hey, I told you I wanted to cancel on the phone. That doesn't work. You have to follow the formal methods listed, like sending a written notice via registered post, courier, or to a highly specific email address. If you don't follow the exact rules in the notice clause, legally speaking, your communication might not even exist.
Next is the phrase everyone suddenly became a legal expert on back in 2020, force majeure. This clause covers extreme, unexpected events that are completely beyond anyone's control. It protects a party from being blamed or penalized if the literal impossible happens and they suddenly cannot perform their end of the contract.
We're talking about massive, undeniable events here. Natural disasters, war, sweeping pandemic lockdowns. If any of these extreme events occur, this clause ensures you aren't sued for non-performance during that specific crisis window.
Our final translation is assignment. This clause simply answers the question, can one party transfer this contract and its obligations to someone else? If it says no assignment without consent, it prevents the other party from just handing your contract off to an unknown third party or some other company without getting your written permission first.
Section 4. Can you actually negotiate these things?
The answer is a resounding yes. They are highly negotiable, especially in business contracts. People assume they're fixed just because they look standard and boring, but you can absolutely push back. Ask to change the jurisdiction to your home city. Ask for clearer dispute resolution steps. Ensure the notice clause actually includes your preferred email address, and make sure that force majeure clause is reasonable. You might not always get exactly what you want, but asking questions and requesting changes is your absolute right. Don't be afraid to use it.
Finally, Section 5, the Before You Sign checklist.
Take a screenshot of this checklist right now. Seriously, keep this on your phone or desktop and run your next contract through these 6 questions before you ever pick up a pen. Because at the end of the day, if you don't read the boilerplate, you aren't just signing a contract, you're signing away your leverage. So it leaves us with one big question. In your last deal, whose rules were you really playing by?